Well, this is probably my favorite subject. And we're going to look at epidemiology from the perspective of an attorney who practices in occupational and environmental law and toxic tort law. Justice Breyer, on our current Supreme Court, back in 2011 said, in this age of science, we should expect to find a, well, that's not working. Technicals. Let's see if this one works. There we go. He said, in this age of science, that we should expect to find a warm welcome, perhaps even a permanent home in our courtrooms. And I have attempted over the course of my career to assure that epidemiology has a current home in America's courtrooms. And Justice Breyer said, poignantly, in this age of science, we must build legal foundations that are as sound in science as they are in law. So Justice Breyer, coming of age as a jurist and among generations that have learned through media and who no longer eschew science, understood the relative importance of having evidence-based medicine and implementing those principles in courts of law. Now, what happens is that clinicians such as yourselves, because most of you are probably concentrating in occupational or environmental medicine, are frequently required to render an opinion concerning whether an adverse health consequence is work-related in a medico-legal proceeding. And it is incumbent upon clinicians to make certain that any opinion reflects a careful analysis of all available clinical findings and high-grade scientific evidence. And one thing I want you to notice this evening is that most of my slides, although it may cause some confusion, are going to have citations on them because that's a duty that I owe to you. These are someone else's words, not my own. And this is from 1979, so there was sort of a precursor to my entire practice as early as 1979 when NIOSH published the Guide to the Work-Relatedness of Disease. What we're going to do tonight is we're going to start out as if you're walking into the courtroom for the first time and determine what kinds of things that court will consider important in determining whether your testimony is ultimately going to be admissible. We're going to talk a little bit about what sorts of methodologies courts of law require to make certain that your testimony is admissible. At the threshold, we start with an expert witness's qualification. The court makes an inquiry concerning whether the expert has the requisite qualifications to render the opinions that he or she offers. I've seen many an instance where we'll have an expert with a 103-page CV and 56 peer-reviewed and published articles on a subject that bears no relationship to the testimony on which she is actually going to testify. So someone who's eminently qualified may not be qualified at all in a court of law. Furthermore, your credentials alone are not sufficient. Without more than credentials, without more than that hefty resume and a subjective opinion, an expert's testimony that it is so is not admissible. At a minimum, expert testimony should include a description of the method that you use. And you'll see tonight there's a constant theme that you must have a method or a methodology that passes muster under the standards for the admissibility of your testimony that have been established in the courts. So the expert's assurance that the methodology and the supporting data are reliable similarly will not suffice. Courts examine whether they are or not. Also of interest is that your curriculum vitae may include 103 peer-reviewed and published articles. They may even include 103 peer-reviewed and published articles on a relevant subject matter, but that alone is insufficient. That's because publication alone does not necessarily correlate with reliability and relevance, and therefore admissibility. Furthermore, and I know Doctors Hegman and Holland very, very well, I'm disappointed in the ever-declining quality of so-called refereed professional journals. And some of the open access journals are very disappointing to me. Publication is relevant, therefore, but not dispositive in consideration of whether or not your technique, your method, or theory has been tested and is therefore based on scientific evidence. Who's heard of the Daubert decision? Quite a few. And how many of you feel as though you understand the precepts that Daubert articulated? And now I have almost no hands. And that's typical. So don't feel as though you're alone. So what the court in Daubert did was to establish a gatekeeper's role. The Supreme Court of the United States held that trial courts must act as gatekeepers to ensure that all scientific evidence is relevant and reliable. The testimony must assist the jury in determining facts and issue. If it isn't, then you're not necessary and it's not relevant. Rule 702 of the Federal Rules of Evidence is the codified rule that governs the admissibility of expert witness testimony. The testimony pursuant to the rule must be sufficiently based on reliable facts or data. And we'll talk later about what kind of facts and data are in fact reliable. Testimony must be the product of scientifically reliable principles, and there's that word again, methods. Witnesses must have reliably applied the principles and methods. Is a screwdriver a reliable method to remove a screw from a plate? In fact, it is, but I want a show of hands. How many of you have used a butter knife to do that? I see a lot of hands. All right? So a butter knife is a very reliable methodology to butter your bread, but it's an entirely unreliable methodology to remove the plate from the switch box. So testimony that's lacking sufficient bearing on the issue of relevance is irrelevant and inadmissible. And the courts must assure that speculative and unreliable opinions do not reach the jury. Expert evidence can be a very powerful and misleading type of testimony because of the difficulty of a layperson in evaluating it, and because of the tendency for them to evaluate your testimony based on your credentials, not your methodology. So Daubert articulated some factors that you should be aware of that will govern whether or not your testimony is admissible in a court of law. And I want to see a show of hands. How many of you have testified in either an administrative proceeding, such as a workers' compensation hearing, a deposition, or at trial in a civil lawsuit? A lot of you. When you met with the lawyer to prepare for your testimony, did he or she mention that there were a few things you should know? That is, did he or she mention that you should be aware of these criteria for the admissibility of your testimony? Show of hands. I see few. When you met for the lawyer to prepare for your testimony, how long did you meet with her? Show of hands, 15 minutes. Show of hands, half hour. Show of hands, 1 hour. Show of hands, 1 hour or more. Show of hands, all day. 2 hours? 3 hours? 4 hours? See, it's incumbent upon the lawyer to assure that you're prepared. It's incumbent upon the lawyer to make you aware of this. So first, they want to know whether the expert's theory or technique can or has been tested. Let's say that the technique is measurement of human exposure to whole body vibration and repeated shock. There's an ISO standard that governs how those measurements are to be taken. And it validates the reliability of those using external criteria to validate it. Whether the expert's theory or technique has been subject to peer review and publication. I'll look back at my old friend, Dr. Bloswick. And Dr. Blazek, how many times do you think that the Michigan three-dimensional static strength prediction model for biomechanical modeling has been the subject of a peer-reviewed and published journal article? Hundreds. Whether the actual or potential rate of error is known. What's the rate of error on the methodology that you're employing? Is it 5%? Is it 10%? Is it 50%? Show of hands, how many of you can raise your hands and tell me what is the actual rate of error of the diagnostic criteria known as differential diagnosis? What's the rate of error there? I submit to you the rate of error is many orders of magnitude than you may imagine. Whether there are standards controlling the technique's operation. Dr. Blazek, can anyone go out and drive the University of Michigan's three-dimensional static strength prediction model? Can anybody drive that model? That's the wrong answer. Whether the expert's methodology is generally accepted in the relevant scientific community. I hate this. This is called the general acceptance criterion. So I want you to pretend that we're in a medieval age. And I want to see a show of hands, given that we're in a medieval age, how many of you think that the earth is flat? Come on, don't be bashful. The point is, that was once a generally accepted principle. So this is an opinion poll. It's a popularity contest. My advice, ignore that one. You know, not every one of those factors that we just looked at, according to the Supreme Court of the United States and the Ninth Circuit on remand, is applicable or relevant to every inquiry. So the overarching subject is the scientific validity and thus the evidentiary relevance and reliability of the principles that underlie the proposed submission. More on methodology. So in Daubert 2, the Court of Appeals concluded that those factors that we just examined are illustrative, not exhaustive, and that other factors ought to be considered. In response to that, the advisory committee notes to Rule 702 were revised to reflect that we should look at whether the expert is proposing to testify about matters growing naturally and directly out of research conducted independent of the litigation, or on the contrary, whether the opinions were developed expressly for the purposes of testifying. Once again, by a show of hands, how many of you have engaged in the design and execution of a peer-reviewed and published epidemiological article? A few. Okay? Those folks, if their research is relevant to the subject matter at hand, can rely on their own research. And if it's been subject to the scrutiny of their peers, courts consider that the most reliable evidence. How many of you have ever been retained as a so-called consulting or retained expert witness to do an IME and testify on behalf of a litigant, whether the litigant is an individual claimant or a corporation? I would have expected that the majority of you would have been. Under those circumstances, you've not been retained to treat that patient. In fact, you've probably told the patient you're not establishing an association between doctor and patient. True? So at that juncture, your opinions have been expressly developed for the purpose of testifying. And now you're in trouble. Because the courts say if it's based on pre-existing research related to the litigation, that provides the most persuasive basis for concluding that the opinions, there's the word again, were derived by the scientific method. But when expert testimony is not based on your own independent research, what do you need to have in your toolkit? What do you have to rely on? Anyone's opinion. The peer-reviewed and published research of others. You need to know the literature. When's the last time that you went in to do a deposition where the attorney told you in advance, I want you to bring the 5 seminal peer-reviewed and published articles on this subject matter with you, and before we meet, you must know them stone cold? Ever happened to any of you? I hope it's happened to you two guys and this one back here. If not, I've been an abject failure. You've got to have that in your bag of tricks. You had to have reviewed that epidemiological literature, and you'll see that examining the epidemiology is a critical requirement in the courts now. Here's another thing. Sometimes the data don't support your opinions. I can't count on both hands and my toes the number of times in several of the fields in which I practice where the objective, quantified data do not support the opinion. There's a disconnect, even though it's a generally accepted, valid, and reliable methodology. Go back to that whole body vibration measurement. It was particularly true of that litigation. So along comes General Electric versus Joyner, once again in the Supreme Court of the United States, and they said conclusions and methodology are not entirely distinct with one another. Although it's true that trained experts commonly extrapolate from existing data, nothing in the Daubert decision or the federal rules of evidence requires a district court to admit opinion evidence that's connected to the existing data only by the, lawyers love Latin, ipse dixit of the expert. What is ipse dixit? Anyone know? Essentially, it translates to, it is so because I say so. A court may conclude that there is simply too great an analytical gap between the data and the opinion. Moreover, show of hands, how many of you have been specially retained as expert witnesses on behalf of a party in a workers' compensation proceeding, other administrative proceeding, or civil or criminal litigation? Have you been retained as an expert witness? Oh, interesting. Not a lot, then. Well, for those of you who have, Dr. Hegman, how many cases have you testified in?
8.
And Dr. Holland? How many?
About 6.
I deposed a guy last week that Drs. Hegman and Holland known, whom I shall not mention by name, who told me he's testified in hundreds of cases in the past year. Well, for those of us who practice law, we call that guy a hired gun. And interestingly, so do the courts. The courts say they have to evaluate whether the expert is a hired gun or a person whose opinion will withstand the same scrutiny that it would among his or her professional peers. That the expert's being as careful in the context of litigation as he would in his day-to-day practice of medicine. And if an expert is the quintessential expert witness for hire, the courts may apply the Daubert factors with greater rigor than they ordinarily would. And further, expert testimony must be based on actual knowledge, not subjective belief or unsupported speculation. This means you must prepare. This means you must know your file intimately. You must have a command of the facts, and you must have a command of the medicine, and you must have a command of the objective and special testing that's been conducted. The testimony is not scientifically reliable if the opinion relies on an imprecise methodology or an inadequate investigation. And this expert in Pretter versus Metro North was an expert for whom I was responsible and deposed, and who did something that I called a drive-by inspection of the railroad yard at issue. When he was being deposed, I asked him, did you observe trained men performing the tasks that are at issue in this litigation? And he said, well, I stood on a bridge with binoculars, and I watched them work for about, well, it must have been almost a half hour. And how far away was the bridge? About 1.5 miles. Well, that's inadequate investigation. That's imprecise methodology. What could you conceivably learn in a half an hour peering from a bridge 1.5 miles away from a railroad yard that would provide you with any meaningful evidence concerning the individual's exposure to physical factors that might have resulted in his or her musculoskeletal injury? Not much. I love this quote. If you're going to dress up in a tuxedo, it better fit you. One who seeks to clothe his opinions in the garb of scientific certainty must adhere to the strict standards of objectivity that formal wear entails. You're not faking it if you're not James Bond. See that scientific certainty in there, tucked in there? How many of you have ever been asked, to a reasonable degree of scientific certainty, doctor? Show me who's been asked that question. To a reasonable degree of scientific precision, to a reasonable degree of medical probability, various permutations of that. How many of you feel like you know what that means? Maybe we should look at that more carefully then. Well, here's an inconvenient truth. Despite popular notions about evidence-based medicine, critical analysis of causation remains lacking in American courtrooms. And I'm indicting my profession first and your profession second. I refer to my friend that I deposed within the last week. This guy is going to testify that myriad nonspecific symptoms that could be associated with multifarious different conditions, serious and otherwise, were caused by a specific exposure to hydrogen sulfide. He'd better know something about the exposure dose. That's quintessential. So what kind of methodologies for the determination of causation are going to pass muster under Daubert? Well, a multidisciplinary method for the determination of causation is not a novel concept. It was initially penned as early as 1979. Why am I so critical about multidisciplinary? Because sometimes I'm going to need an occupational and environmental medicine physician. Sometimes I'm going to need an orthopedic surgeon. Sometimes I'm going to need a biomechanist, a biomechanical engineer who can quantitate the exposure. Sometimes I'm going to need someone who's a sine qua non epidemiologist. Say I were involved in the talc litigation. I'd need an expert witness who was a sine qua non epidemiologist. So I need a team. One size does not fit all. Go back to my friend that I deposed in the last week. He's purporting to testify concerning psychological outcomes. He's purporting to testify concerning neurological, psychological testing instruments. How many of you would be comfortable testifying about a psychological outcome, let alone the details of neuropsychological testing? I don't see a single hand in the air, not one paw in the sky. And yet, he's going to testify about that. You know what else he's going to testify about? Air dispersion modeling. Because we had a hydrogen sulfide leak. We better figure out what the concentration was, right? Which direction it went, what the concentration was at the recipient. How many of you would feel comfortable about that? How many of you would feel comfortable testifying that hydrogen sulfide gas is toxic? Show of paws. How many of you would be more comfortable testifying that hydrogen sulfide might be toxic, provided that it's present at sufficient frequency, intensity, duration, and temporal pattern of exposure to result in an adverse health outcome? It can be toxic, but it is not necessarily so. How do I know that? Heck, I've had halitosis. How do I know that? Because I've been in a room full of, shall I say, people who made me uncomfortable. I've been around a swamp or two. You know, you got to have it there in a sufficient dose. So you can't just say, oh yeah, it's toxic. So NIOSH comes up with this guideline, and what it does, look at this language from 1979. It presents one method for assembling and evaluating evidence that may be relevant. Look at that. It's almost a premonition in determining the work-relatedness of disease in an individual. So it's a six-step process. And the first is consideration of evidence of disease. And what that means is an adequate case definition for the adverse health outcome or outcomes of interest expressed in terms of the objectively known and generally accepted diagnostic criteria. So what's carpal tunnel syndrome? Is carpal tunnel syndrome numbness in the hand? Is carpal tunnel syndrome numbness in the thumb and these fingers? Is carpal tunnel syndrome numbness and tingling, that is paresthesias, in the thumb, second digit, third digit, half the fourth digit on the median side with confirmatory electrodiagnostic studies over the wrist? How many of you think that's an okay definition? Kurt? Anything you want to add to it? Characteristic clinical signs and symptoms. Maybe you want a positive phalanx or Tonell's, but we know that's only good because it's like a coin toss 50% of the time. Point is, we can't just say, oh, he's got numb, tingling hands. He has carpal tunnel syndrome. Here's the one I want to focus on. Consideration of epidemiological evidence. Consideration of individual exposure. Was it measured and quantified according to a valid and reliable methodology? That's why I need Dr. Don Bloswick, because I want to know what the stress on the joint is. I want to know what sort of compressive forces were generated at L5-S1. I want to know what the individual joint strength capability is in the shoulder joint. I want to know how many among a typical population have sufficient strength to perform that task. That's why I need that guy. That's why Kurt needs that guy if Kurt's my back guy. Consideration of other relevant factors simply means what are the relevant factors, what other personal health conditions, personal health attributes, lifestyle elections, avocational activities might be causing or contributing in a multifactorial way to the outcome of interest. Consideration of the validity of testimony of others. Let's go back to my imprecise methodology guy. Is that testimony of the kind that a person in your area of expertise would reasonably rely upon in forming opinions and inferences on the subject matter? And sometimes the lawyers will stick you with a guy like that because they're asking you to rely on someone who made no effort to quantitate the exposure in a valid and reliable way. So you have to look at the other guy's experts to reach your evaluation and your conclusion. Well, this darn thing's from 1979. So, is the NIOSH guide relevant or a relic? Who thinks it's still relevant? Majority of you. I'm going to agree with you. I'm going to agree with you as recently as February of this year, when Dr. Hegman was the editor of a panel that addressed ACOM's new work-relatedness guidelines. I'm going to agree with you because in 2008, the American Medical Association adopted that same methodology. And I want to agree with you because in 2004, then revised in 2008 and 2011, the American College of Occupational and Environmental Medicine adopted those. And they're not alone. The American Medical Association guidelines for the evaluation of disease and injury causation adopted that methodology. And in fact, they said that it was developed by the National Institute for Occupational Safety and Health and adapted by the American College of Occupational Medicine because this may be the most common structured method used, and it does not seem to have any major weaknesses. It is the method used herein. It's elegant in its simple logic and in its way to collate evidence from multidisciplinary expert witnesses. So it's legally sufficient in a court of law, provided that it's conscientiously applied. Because we could take any one of those 6 steps, right? And we could fall down on the job on any one of the 6. And if you fall down on evidence of disease, if you don't have a good case definition, I'm going to close my briefcase and go home. And if you fall down because you don't know anything about the relevant epidemiological literature, for example, on the development of carpal tunnel syndrome, I'm going to close my briefcase and go home. And if you don't know anything at all about the measurement and quantitation of the individual's exposure, I'm going to close my briefcase and go home. If you haven't read the deposition of the opposing experts, or you haven't read Dr. Bloswick's biomechanical modeling report, I'm closing my briefcase and going home. If you fail to consider whether or not an individual who's alleging that she has contracted ovarian cancer as a consequence of perineal talc application, but she has a history of tubal ligation and bilateral oophorectomy, those are other relevant factors that you ought to have known about because they occlude the reproductive tract, true? So I'm going to close my briefcase and go home. We're never going to get to your evaluation and conclusion. It's never going to see the court of day. Epidemiology is a study of the distribution and determinants of disease among human populations and the application of that research to prevent future adverse health consequences. Everybody pretty good with that definition? Is epidemiology important in courts of law? Well, the courts have said that expert testimony founded on epidemiological data is a fit subject for judicial notice under Rule 201 of the Federal Rules of Evidence, which states that a judicially noticed fact is one that is not subject to reasonable dispute, or alternatively, that the facts are generally known or capable of determination by resort to sources the accuracy of which cannot be reasonably questioned. Now, I know that epidemiology is populations-based, but I've got a choice here. I can rely on populations-based epidemiology, or I can rely on no evidence at all. And I refuse to rely on the latter. So here's what the courts have done with the conundrum that epidemiology is populations-based. A substantial body of legal precedent establishes that epidemiological evidence is critical to prove causation in an individual through probabilistic means, because it tells us the type of person likely to contract it and the nature, that is the frequency, the intensity, the duration of the exposures to relevant factors that are capable of generally causing the outcome. So courts have recognized the utility of epidemiological studies. But it's interesting because you have to have evidence of both general and specific causation. Who's comfortable defining general causation for me? Who's comfortable defining specific causation for me? Oh, I guess we have Houston, we have a problem. General causation means the agent of interest is generally capable of causing the adverse health consequence of interest. Specific causation means that the agent of interest was present and that the presence was of sufficient frequency, intensity, duration, and temporal patterns of exposure to cause the adverse health consequence in the individual litigant. With me on that? Okay, we're going to take all of the epidemiology on any given subject matter and we're going to stack it up on the table. Good idea? Because we want to know what the epidemiological evidence says about the problem with which we're confronted. Well, what the AMA guide says, what the ACOM guide says, what the NIOS guide says is you got to get that stuff, you got to collate it, and then you need to evaluate it. You need to evaluate the individual studies. First things, go through them and say peer-reviewed or not. If it's not, in my arena, not necessarily in yours if you were a clinician treating a patient, but in my arena, that goes in the round file. And then you got to go through these additional criteria. And these additional criteria are articulated in the Work Relatedness Guidelines recently published by ACOM. And then this Sinclair guy adapted and augmented them based upon his irrelevant machinations and the Federal Judicial Center and National Research Council's Manual on the Admissibility of Scientific Evidence. So these are my proposals. I've got an article from 1953 that relates to the development of ovarian cancer as a consequence of perineal talc application. How many of you, just gestalt, think that remains a relevant reference? No. So you got to look, is the research reasonably contemporary? Is it consistent with current knowledge, for example, of the pathogenesis or the generally accepted route of exposure? Next thing, case definition. In that study, are adverse health outcomes defined in accordance with objective diagnostic criteria? There's a great study out there on carpal tunnel syndrome. It's well designed, it's well executed by a person whom I enormously respect. However, the case definition did not include electrodiagnostic studies. It's a very early study. It's a seminal study. The question is, did it diagnose carpal tunnel syndrome at all if no electrodiagnostic studies were performed? I would submit no. Population selection, you got to look at that in every single study. Are the populations well defined? Are the samples selected to provide meaningful comparisons between study groups and time periods? And are the populations sufficient in number? That is, are they representative of the population you want to study, firstly? And secondly, sufficient numerosity to adequately power the study? You got to look at that. Information bias. Were known or potential sources of information bias recognized and accounted for? I'm going to go back to the talc literature because I've spent the last 2 months of my life on the talc literature. The vast majority of studies dating back to just after the mid-70s are case control studies. What's going to be the fundamental Achilles heel of case control studies, especially if one of the populations has the disease and there's been considerable media attention devoted to the disease, and there have recently been numerous multi-million-dollar verdicts related to perineal talc application. You can say it louder because you're right. Recall bias. And there's a bunch of them. Do they recall it? Do they report it? Do they actively report it? How did the questionnaire ask the question? If they sat down with someone on the telephone, do we have an interviewer bias? Is observer bias afoot? What are the attrition rates? Do we have a survivor effect problem or dropout problem? Is there volunteer bias versus randomized selection of controls and cases? Is there compensation bias? All kinds of information biases afoot. Confounding. Were confounding variables recognized and accounted for? This is that multifactorial comorbidity issues. Did we account for that either by excluding persons with potential confounding factors from the study, or alternatively, and less significantly, did we account for that through statistical means? Because we can statistically adjust. I'm not saying you can't and shouldn't do it. Exposure assessment. Let's get back to, we have these putative risk factors. Did we use a valid and reliable methodology to quantify the exposure? Or did we use occupational title? He works as a train man. Or group membership, the whole body vibration literature in the transportation industry. Are you a member of the transportation union or not? That's group membership. What's that tell me about individual exposure? Are the exposures sufficiently homogeneous among multiple studies to permit comparison? Or let me say that the other way around. Is there statistical evidence of a lack of heterogeneity so that I can take a bunch of studies and utilize those studies in a meta-analysis? What's the research design? It's greater credence is accorded to prospective cohort studies for epidemiological questions. There are, however, inherent limitations and advantages to all study designs. Meta-analysis, sufficient homogeneity to incorporate those studies in a meta-analysis. Is that possible? Exposure-response relationships. Is the rate or severity of symptom, disease, or disorders predicted by a change in the exposure dose or the temporal pattern of exposure? Because if I increase the frequency and duration of talc use among a population of women, I should see an increased number or increased severity or increased progression of various different histotypes of ovarian cancer. So are those things modulated? So if I turn the volume knob to the right, does the radio get louder? I'm going to look at that. Statistical quality. Examine whether the statistics were rigorous. I looked at this meta-analysis recently in the talc literature, and I was blown away at how good it was. Not a narrative literature review, but inclusion criteria and exclusion criteria and statistical analysis of heterogeneity and remarkably rigorous statistical analysis. That study meant a lot to me. You know, that one was like front and center on my desk because it was so well designed and so well studied. And then the studies were very large numbers. So I had tons of statistical power, especially when I combined these studies. And then are the reported differences, see, usually we say significant, right? But at law, we have to plug in statistically significant because people think, well, it's significant in a layperson's terminology, right? But I'm really looking at statistical significance. And so I say, what is the ordinal magnitude of that significance? You would be astonished. You know, what's a typical P level that you want to use, that you'd usually use? Kurt? 0.05, right? You'd be surprised at how many studies I look at that in order to get a statistically significant result, they use a P level of 0.10 or 0.20 because they get a significant result. And a significant result gets published, right? Positive association goes in the journal. So I want to look at that in every single one of these studies. I've got piled up on my desk. Okay, now I got to take all these studies and I say, I've got 10 studies here, 15 studies, and on the first cut, the evaluation of the individual studies, they look pretty good. In Amorgianos versus National Railroad Passenger, the court addressed very specifically the vital role of epidemiology in the determination of causation in toxic tort actions. The court observed, their words not mine, there are several different forms of epidemiological studies in occupational medicine. These various designs differ in their evidentiary weight and whether they're hypothesis generating or hypothesis testing designs. So I stole something from Kurt, but I did give him credit. So you start at the top of the pyramid with a prospective cohort design, retrospective cohort design, then we're down to case control, then we're down to ecological data, and then something very interesting happens. Let's cross the line. Consecutive case series, case reports, and a case report. So by show of hands, are the studies below the line epidemiological studies? He's nodding his head negatively. You're nodding your head negatively. Okay, let's try this again a different way. Are the studies below the line anecdotal and hypothesis generating and subject to every manner of information bias? Because you've got a single physician attending to a single population in a single area, and so you have referral bias, and that's a case report, and then you move up to case reports, plural, and then consecutive case series. That doesn't mean that those are not valuable. And in fact, let's go back to our hydrogen sulfide example. The major thing with hydrogen sulfide gas is what's the intensity of the exposure? What's the concentration? And That's not something that we're going to study in epidemiological literature over time necessarily, but we sure do have case reports where we know what the concentration was, and we know we have a knockdown, or we know we have a death. So they're valuable for that reason, because they help us figure out what exposure dose might be lethal. So the court in Amorgiano says, in an epidemiological way to the evidence analysis, those higher quality study designs outweigh the lower quality studies, provided that they have no significant flaws. In absent randomized control studies, the highest quality study is the prospective cohort study. So I'm going to draw up again, go back to this immersion that I've been in the talc literature. Case control studies of perineal talc use, genital talc use, application of powder in the rectal region, and what kind of powder are we talking about? Okay, are we talking talc powder? Are we talking cornstarch? Are we talking talc powder potentially contaminated with asbestos fibers? Are we talking about talc powder and cornstarch? And they're almost all case control studies. How many of those do we have? How many case control studies do we have of that vaguely defined principle? Hundreds. How many cohort studies? Longitudinal prospective cohort studies. How many do we have? 3. Of the 3, how many of them have found an association between perineal talc use in very large numbers populations? I'm talking populations up around 90,000 subjects. How many have found that association? Oh, Houston, we have a problem. Houston, we have a problem because the cohort studies don't find it. Have they examined the outcomes? How many histotypes for ovarian cancer? Anybody know? 5. How many of the studies individually stratified the data to examine each of those? We don't know. Houston, we have a problem. How many of you remember the breast implant litigation? Was there scientifically valid and reliable epidemiological evidence to support the adverse health consequences as a result of breast implants? Sir, you're nodding into. You can't trust us. How many of you knew that before now? You can't trust us. So don't. Okay, I still love this case. How many of you would rely on 2 or 3 epidemiological studies for proof of causation? If you had 100 studies, all of which found an association, would that be enough? Some of you are saying yes, some of you are saying no. You're a little equivocal on me. Well, it depends on the quality of the studies. And what does Daubert demand? What do we know by now? It's the M word. A method, a methodology, a scientifically valid and reliable methodology. Fortunately, we have one. How many of you know these guys? A.B. Hill guidelines. This is not all of them. These are the ones that I look at with the most intensity. What's the strength of the association? I've got an odds ratio of 1.2. I've got a confidence interval at a p-level of 0.05. The confidence interval is 1.02 to 1.4. What's the strength of that association? That's pretty good for a talc study. All these associations are well below 2.0. Almost all of them are below 1.5. Even in the well-designed stuff. Okay? So what's the strength of that association? Okay, now I've got an odds ratio of 2.1 and a confidence interval of 0.08 to 2.7. You feeling good about that, sir? Why not? Precisely. It crosses over. Moreover, that confidence interval is big enough to drive a bus through. What's the specificity of the association? Ovarian cancer, is that good enough? Or do I want invasive serous cancer of the ovaries? I want the latter, don't I? Because if I say ovarian cancer, I got 5 different histotypes to deal with. Oh, and who thinks ovarian cancer gets confused with mesothelioma? A lot. Temporality of the association. Listen, the horse does have to come before the cart. Honest. You got to have a dose-response relationship. Back to my current best friend, the talc literature. I want to look at those animal studies. They're all over the place. They're inconsistent. Most of them don't find a dose-response relationship. A few of them do find a dose-response relationship, and I can't figure out what the mechanism or the theory of pathogenesis is, and I can't figure out what the exposure route or route of exposure is. And I have to have biologically plausible theories for both, don't I? Sometimes it's that simple. Let's get back to my old friend, general and specific causation. Courts get it. They say, in a toxic tort case, the plaintiff must establish both general and specific causation. So the plaintiff has to demonstrate that she was exposed to the toxic substance and that the concentration of exposure was sufficient to induce the adverse health outcome of interest, which the court said is commonly called a dose-response relationship. Read this case, a great case out of the Sixth Circuit. And the court said both causation inquiries involve scientific assessments that must be established through the testimony of a medical expert. So we need you guys. In fact, we can't prove these cases without you. Your testimony is quintessential. It is a prerequisite. Without expert testimony, a plaintiff's toxic tort claim will fail. Why? Because as laypersons, a jury is not well endowed to figure out the conundrum. So the dose is the poison. An expert testimony has to prove there's a chronological relationship. Remember I said the cart has to come before the horse? Nah, the horse has to come before the cart. The expert considered the likelihood that the chemical caused the disease in the context of other causes. Carpal tunnel syndrome was a great example because you had all these personal health conditions that were associated, like obesity, morbid obesity, and diabetes mellitus. And then you had people who had all sorts of very forceful, very repetitious avocational activities with very brief, if any, recovery periods that were much more stressful than what they were doing in their day-to-day occupation. So along comes this other case that I love. And the Adams Court says, the issue of causation, this is a quotable quote, the issue of causation is not merely a question of science, but a question of law. And that evidence presented by plaintiffs' experts may have demonstrated defendants were responsible for an inadvertent release of chemicals, like my hydrogen sulfide release. It was inadvertent. It was caused by mine subsidence. It ruptured the production tubing in an oil and gas well that produced high amounts of hydrogen sulfide that were measured right at the wellhead in the area of 400 parts per million. But testimony may have demonstrated a causal association between such chemicals and disease. That's general causation. However, such evidence did not prove that the defendants were legally culpable for plaintiff's decedent's death because it did not establish the decedent was exposed to a sufficient concentration of the chemical to have caused the injury, and because it failed to exclude other possible causes. So I want to go back to my hydrogen sulfide case. We have air dispersion modeling at the plaintiff's residence, and we measured hydrogen sulfide that exceeded the olfactory threshold. We got about 2 parts per million at the plaintiff's residence. So you could smell it. Okay? We measured at a distance of 40 feet from the wellhead. We got 38 parts per million. We measured in the wellhead, and we got 400 parts per million. And we measured at the plaintiff's residence, and it was non-detect. So who thinks they get over the second hump in that case? Sure, hydrogen sulfide can be toxic, but we've got hydrogen sulfide that's right around the olfactory threshold. It's many orders of magnitude below that concentration that you would expect to cause an adverse health consequence. Moreover, you got to toss out all this other stuff. So we've got a person who claims that their exposure to hydrogen sulfide gas caused irritable bowel syndrome. Does anybody know of any association between hydrogen sulfide gas exposure and irritable bowel syndrome? Can anybody point me to an epidemiological article that establishes that? Okay, so I got nausea. I've got diarrhea. I've got constipation. I've got vomiting. I've got blisters in the mouth. I've got the ability to smell hydrogen sulfide and anosmia, the inability to smell hydrogen sulfide. I've got all that stuff going on. Who thinks any of that stuff is consistent with a single, well-defined adverse health outcome case definition? I mean, I've got a myriad of non-specific symptoms that could be associated with anything, right? So that's not telling me much. So I've got to exclude these other possible causes. I have a person with pre-existing mental health history. I have a person whose lifetime adult maintained weight is greater than 35 BMI. I've got a person that smokes 3 packs per day. So I've got a woman who weighs about 263 pounds. She's about 5 feet 7 inches tall. She smokes like a chimney, and she has shortness of breath on exertion. Duh, Homer. So the NIOSH guide says the commonly seen statement that in the absence of other obvious causes, the problem is work-related should not be used. Why? Because that's a logical fallacy. So along comes this other case I like, and in that case, the plaintiff's physician purported to adhere to a differential diagnosis methodology. Do you all use that, differential diagnosis? Okay, let's look at it critically. What this person did was they excluded all plausible pre-accident causes. They excluded all plausible post-accident causes. Therefore, the accident remained the only plausible cause that could not be excluded. Who thinks that coincidence proves causation? See, that's what's called a diagnosis by exclusion. And the problem with that is the expert had failed to acknowledge that there's insufficient epidemiological evidence of causation. Specifically, many diseases and disorders are idiopathic, and the expert failed to recognize that fibromyalgia has no known etiology. Now, I know some of you may disagree with me on that, comma, but. So, the court said this kind of analysis is tantamount to concluding that because alternate causes had been eliminated, the accident was the cause in fact, and that's not an exercise in scientific logic, but in the fallacy of post hoc, propter hoc reasoning. which is as unacceptable in science as it is in law. Who remembers post hoc propter hoc fallacy from their undergraduate education? Well, see, lawyers love Latin, so we throw it out there because it makes us feel like we're smart, but we're really not. And all it means is, after this, because of this. So it's that situation where you're into coincidence equals causation. So calling something a differential diagnosis does not answer the reliability question in a court of law. In fact, it prompts three more. Did the expert make an accurate diagnosis of the disease? That gets us back to our case definition, right? Second, did the expert reliably rule in the possible causes? Did the expert reliably rule out the rejected causes? And if the court answers no to any one of those questions, then the evidence must be excluded. Fortunately, we have some guidance on this. The AMA guides on apportionment say, first one must consider all potential causes. Second, one must determine whether each potential cause is a probable or possible cause. And probable causes are included in the apportionment analysis, and possible causes are not. Now I'm 5 seconds over time. You good still? Okay. How many of you understand the civil burden of proof? We got a problem again. The civil burden of proof requires a determination based on the admissible evidence that the probability that an alleged cause resulted in the injury or disease is greater than 50%. This is the old scales of justice analogy, where you have to tilt the scales ever so slightly in favor of causation. Well, whether cause and effect is more probable than not is different than statistical significance, and everybody screws it up, particularly my profession. So the common error that attorneys and judges and even expert witnesses make is to conflate statistical significance with the legal burden of proof. So what they conflate is a p-level of 0.05 as though that's the requisite for proof of causation, and that proof of that order of magnitude is unnecessary in civil litigation. That's wrong. Increasingly, courts recognize that when they're sorting through all the epidemiological studies that both litigants have piled on their table, that only those studies that demonstrate a significant association between the exposure and the outcome are admissible in the first place. Once they determine whether or not the studies are admissible, then we get to the issue of whether or not we've proven it's more probable than not. And the epidemiological evidence alone is not enough. To a reasonable degree of medical certainty, doctor, how many of you have answered that question before? Have you answered it? Do you know what it means? When you answered it, did you know in your brain, I know what to a reasonable degree of medical certainty means? So there's a case. And it says reasonable medical certainty reflects an objectively well-founded conviction that the likelihood of one cause is greater than the other. Doesn't mean you're absolutely certain. Doesn't mean you're clairvoyant. It means that you use the NIOSH methodology to adequately collate and analyze the data. How reliable is self-reported medical history? A patient comes in, and you're going to rely on that patient to describe his or her symptoms. You're going to rely on that patient to describe his or her exposures at work, right? How reliable is that information? Show of hands, who would reasonably rely on that information? Nobody? Wait a minute. I thought your sworn duty was to be an advocate for your patients. Is that your sworn duty? Who thinks that's your sworn duty? I see some people nodding their heads. I want to propose to you that if you want to be an advocate for your patient, advocate sound science and evidence-based medicine, because you don't want to medicalize an issue that isn't, right? Because what you do is you're contributing at that juncture to negative psychological outcomes and you're contributing to disability and impairment, which may or may not truly exist. So I want to show you the money on this. This is a collation of the literature on the subject by the AMA. Literature confirms that individual patients frequently provide inadequate medical histories. In medical interviews separated by 1 year, 42% of initially reported historical complaints were forgotten. What kind of bias is that? That's recall bias. Only 41% of healthcare visits in the prior 12 months were recalled, and 28% of the visits claimed in the past 12 months it never actually occurred. Huh? How many of you think that compensation bias, that is, involvement in a medico-legal proceeding, influences the reliability of reported exposure medical history? Show of hands. How many of you think that's poppycock? Oh. I might get out of here alive. Well, the history bias of litigant individuals, whether they're plaintiffs or claimants, compared with non-litigant individuals has been reported. And litigants demonstrated a statistically significant tendency to claim superhuman, their words not mine, pre-injury functioning in 15 of the 16 areas that were assessed. In fact, Carnegie et al., who knows Gene Carnegie? Okay, this guy's a superstar. He's chief of spine surgery at Stanford University Medical Center, and the guy, for me as a lawyer, the guy's a god. I mean, if someone were going to operate on my C-spine or my L-spine, Gene the knife. Gene Carnegie is awesome. Anyways, says Kurt, says John, says Don. I get to work with really good guys. I'm a lucky guy. Carnegie reported on patients with neck or back pain after an MVA. And what they did is they interestingly compared the medical records prior to an MVA to the patient's stated histories. And they discover that an overwhelming tendency for MVA injury claimants to falsely deny any pre-existing conditions of greatest relevance to persistent back and neck pain, such as previous back or neck pain, psychological distress, and prior MVA. Such omissions were present in an astonishing 80% of all claimants, and 90% in a second study of legal claimants where the other driver was clearly at fault. Here's the interesting wrinkle. But control medical conditions in the study, like diabetes and hypertension, which are conditions likely considered by the litigant as unrelated to the injury, were reported consistently. What kind of bias is that? It's two kinds. First is recall bias. More probably, it's reporting bias. So we got those two biases afoot there. So that gets us to the issue of whether or not non-specific symptoms are the quintessential example of information bias. Lees-Haley looks at this issue. Non-specific subjective symptoms including headache, fatigue, skin, eye, and throat irritation, dyspnea, nausea, gastrointestinal disorders, myalgia, and back and neck pain are ubiquitous. Does that sound like my hydrogen sulfide lady? She's a poster child. There are more common in the community symptom surveys when pollution, hazards, contaminations, or health threats are perceived, real or not. I do some work for the oil and gas industry. There is a perception that groundwater is being contaminated as a consequence of modern methods of gas extraction. Horizontal drilling, have you heard about that? Hydraulic fracturing. Everybody knows that contaminates the groundwater and the surface water. Everybody knows that methane is toxic. Everybody knows that the oil and gas operations are belching toxic fumes into the environment. The only dilemma is that the air monitoring doesn't establish that. And the only dilemma is I've done, at this juncture in my career, 1,000 groundwater cases. You know how many I've found evidence for contamination? 6. And it's just looking at the evidence. It's just looking at the data. There's truth in numbers. There's truth in data. So when there's this perception, or when there are other things afoot, like the fact that you used to live in a relatively quiet neighborhood in a rural area in north central West Virginia, and suddenly you have a well pad that's lighted up 24/7, and there's some noise associated with traffic coming and going, and there's dust, you can have a perception that adverse health consequences are likely, but here's the truth. Symptom data are often used as an index of the health consequences, especially in cases of environmental exposures or alleged overexposures to some perceived hazard, including workplace exposures. Symptoms are, however, unreliable measures because they are so colored by fear, emotion, and especially litigation. Well, that's my story, and I'm sticking to it. I had to add this slide because I wanted to prove to you I was really a lawyer. Thanks very much. Yes, sir.